new to January and February of 2020 is the practice law, practice. This is generation 11. This is a generation 10. Generation 11 does not exist in the public disclosure and in open community, but this is a generation 11. Look at this, how it hovers and repels around the system here, the Benton County and the Justice Department here, over 100 millimeters. It's a beautiful piece of the machinery. It doesn't run on fuel. It doesn't run on aviation. It doesn't run on nuclear activity. It doesn't run on petroleum, uranium. It sits there and hovers all around. Look at this. It doesn't run. It does it 24 hours, 7 days a week until someone destroys it or tries to. And other units come and look for it, looking for the recovering information. It's a sad, sad thing. It's a giant fettered resource, understanding center, retaining annuity trust. This is the properly secured, funded, granted, retained annuity trust. This G-A-R-I-T, the G-RAT. The G-RAT, the G-RAT of the town. G-R-A in parentheses. Look, it says G-R-A-T. Look at that. You want to read that up? Look, it says, can you be powerful estate freeze type planning tool for the wealthy individuals seeking to reduce, eliminate imposition of gift, estate taxes, transfer their assets, simple terms, GRT. Design the freeze and transfer tax value of asset contribute to its contribute date. Any subsequent appropriation. This is APR rate. Anything cumulative in a savings or checking, or of course the $35 million in account of the services they got, as you can tell. Be superseded and put it in, and it's called a concentration. It's a subsequent appreciation of these assets. Can be transferred fee, transfer tax, designated remedies, beneficiaries, split state result, GRT, typically funded with assets likely to appreciate meaningful during a trust term. See, it appreciates APR, it collects interest. The hallmark feature of a GRT grantor is retention of the right to receive a specified annual amount each year for the terms of years. The value of this annual initial gift and grant. Technology, the greater in surprise, the final and minor beneficiaries. State meaningfully exceeds individual account prior gifts, spouse deductions, more particular assets, or substantial appreciation for the future. The trust estates include resource practice note 7, practice note 9, and practice note 10, Microsoft. And this is Microsoft components and tablets in generation 10 and 11. And then with this practical necessity plan, attorney confiscation, notice practice note, estate planning, duty confidentially. And this is confidential information, confidential note, ethics, client, relationship, basic, and the standard document letter of trust of married couples, services. Act and act. Court, and this is Ricardo versus Dennis criminal law, injunction in from the seek and remove petition proceedings where based in your left right jurisdiction. United States versus T81016 Day Engelhardt, and is in criminal law like Eagle Earnhardt was slammed in the wall and killed because he was a fool that ran from Felix Barela. Simba, which be John Force, her father, runs from Felix with his homeboy. The Fifth Circuit affirmed defendant sentence imposed and pleaded guilty of conspiracy opposed to the intent of discernment controlled substance. Now Simba is applying a plan of error. Now Simba stands the statue of Spokane, Washington, across the Chamber of Congress. Now Simba sits in front of the black belt, and they want to be a neo-Nazi parties, and the services where their bones, the structures of bone, are always. The district court special respondents and evidence of drug quantity 45 kilos failed to carry the burden proving would have received lesser sentence. See, there's nothing in my system. There's no steroids in my system either. U.S. Court of Appeals, 10th Circuit Court. Aga Kong. OGAWA versus Kang, C-A-N-K, docket 184082. Opinion date January 6, 2020. Judge Mertz, M-O-R-T-I-Z. Like Mertz, Marina, like the yacht club. Now, areas of civil law, procedural, family law, international law, Japanese national, Takase Aga Hagavision, eviction, but there's no eviction because there is an action before the eviction. So he did very good on this one. Master Sensei did very good on this one because against the former wife, South Korean national Kang Kang, allegedly that she wrongly moved their twin daughters from Japan, which they were parked at Gazi University. It says Japan on it. Order requiring these twins return to Japan. Disturbed these individuals, which were none, it was made up because the district court disagreed in denying this position of hers. Conclude that the twins' removal to the United States did violate Ong's rights of custody, parked in the parking lot at Gazi University. Actually, a federal court, judges' chambers area. This twins' removal to the United States did not violate Ong's rights of custody. Alternative, even their removal was wrongful. The twins' objection returning to Japan. Ong, OGAWA, appealed after review of 10th Circuit Court of Appeals, determining Ong failed to make prima facie showing he had any rights of custody conviction defined them, accordingly affirmed district court's order. I'm sorry, international court complimented Mr. Donald Trump and Melania Trump and Ganja does not concur with this service of yours. You're wrong. You're a lying fool. You're just trying to lie out of yourself being pushed into a grave that you dug yourself into and put the niches and the screws onto the bolts and the niches and the casket into the niches and the processing and the backhoe and the hydraulic oil system and the drums. You're just trying to make things up. Oh, please. No. That's George Washington. Please, can I talk to you now? You're on my fence line. Because you says right here, January 6, 2020, 18-2165, Joseph R. Kelly Jr., Paul, judge. Custody law, criminal law. Defendant Pillager Myers Robertson plead guilty to the possession of firearm. You plead guilty to this charge, my son. And you're a felon, a criminal. See, this gun, I didn't sell you this gun. I didn't give you this gun. I didn't sell this gun, and I didn't do nothing. I know nothing about